Good afternoon. How are you doing? All right, I'm Kevin Ellis, Union President. I want to give you a brief update as to where we are and what's happening, okay? Because there's a lot of moving parts happening in the federal government right now. And I believe that some of the chaos by the federal government, especially the White House, is to keep throwing so much at the wall that it kind of overwhelms the system and the people. But we are standing strong, and I want you to be aware of that. You guys may remember, I think I told you back in July that a lower level district court judge ruled that the agency could not, the agency cannot unilaterally cancel a contract. Those are similar to written binding agreements. And as a result of that, the agency had agreed that they were not going to touch any contracts. They were not going to touch them. They were going to wait and let the process play itself out through court. And halfway into the process, the agency decided to change their mind and go back on the words they told the district court. I mean, they told the Ninth Circuit Court because they filed an appeal over it. Well, that raised so much of a fuss that we did not have to file a brief asking the Ninth Circuit Court to look at the issue all over again. They decided to do that on their own and then required the party to submit a brief to them as to why they should relook at the issue again and what harm has been caused. I am glad to announce to you that that brief has been filed. That it was filed about a week and a half ago um, to the Ninth Circuit Court. So we're expecting any day now to hear a decision from them to rehear the issue of the injunction. Let me be very clear to you. The merits of the case have yet to be litigated. I believe the litigation on the merit of why there should be contracts in place and why they are legal and binding, I believe it's scheduled for late October or early November. So those merits have yet to be argued before the court. What's being argued right now is the injunction that the district judge put in place by saying, no, you cannot unilaterally cancel a contract. Those are legal and binding agreements. You cannot just go in and just wipe them off the books. That was the injunction. But because the VA and the White House said, we're not going to touch anybody's contracts, we're going to let the process play itself out, let it go through the judicial system, and then we'll go from there. This is what they told the Ninth Circuit Court when the appeal was filed. And as a result of that, they reneged or failed to honor those words. And for that reason, the Ninth Circuit Court said, wait a minute, you told us that you were not going to touch anything, that you're going to let the process play itself out. And for that reason, we lifted the injunction. Now, the Ninth Circuit Court has asked us to come back and give them a brief as to why they would need to relook at the issue and explain what type of harm has been done. So I'm here to tell you that brief has finally been filed. Okay. So tell your coworkers, tell your friends, tell your peers, this fight is not just about AFGE and our contracts. This fight is about the contract with America. These contracts, private sector unions, public sector unions, are doing nothing more than speaking for and representing you and me, the American workforce, period. That is what they do. So we want you to tell your friends, your family members that AFGE and the private sector unions are all being targeted by the White House. And everybody is going to be impacted unless we all bond and join together. A perfect example of that is when the government shut down right now. And the shutdown happens to be not about AFGE, not about federal employees, but what about the health and safety of the public, the general public. One issue that's been argued that the Democratic Party is fighting for is health care subsidies. You might recall before the Affordable Care Act, uh, families were having bankruptcies due to medical conditions. You might recall that families in this country, if they had pre-existing conditions, they could not get health care. And for that reason, we have people dying because they couldn't get to the hospital. We have families that was needing life-saving medical care, was having to file bankruptcies and lose their homes, their houses, lose everything they had just to stay alive. Here comes the Affordable Care Act, or ACA, or Obamacare, and it made that illegal. Now, what's happening now is the White House is saying we don't want to protect any of them families ever again. That's over and done with. We're going to cancel them subsidies. And as of right now, that plan is set to take place at the beginning of January. Families are already receiving notices of how much their premiums are going to go up, and the premiums are doubling. If a family was paying $330 a month for insurance, it's now jumping to $660. If they were paying $200 a month, it's now jumped to $400. So them prices have begun to be unreachable for many other families. A lot of families are going to have their insurance just outright canceled. That's what's been fought for. Okay, so that's part of what's been fought about in the government shutdown. But not only do you have that occurring, you also have people who are set to lose their Medicaid and their Medicare. Medicaid and Medicare may not affect you and me right now, today, but it affects somebody in our families. Someone in our families are relying upon Medicare, relying upon Medicaid as a means of staying healthy and staying alive. And right now, those services have been cut. That's another thing that's been fought for in this government shutdown. Families who rely upon food stamps or SNAP benefits, those benefits are set to be cut by this administration. Now, think about this: the tax dollars that are going in doesn't belong to the White House, and it doesn't belong to members of Congress. They are tax dollars that are paid by you, me, our family members, and our neighbors. And we've all agreed, about 70% of the country says them tax dollars should go to help the most vulnerable amongst us. Food stamps, Medicare, Medicaid is where them tax dollars should be going towards. So the fight in Congress is not just about AFGE. The counting of the contracts is not about just AFGE, but it's about the American workforce. Now, not only is the administration attacking the federal workforce, they're also attacking the public workforce. Now, now, what does it mean to attack the private and the public workforce? If you recall, the reason why we had unions was for worker protections. Families were being required to go without any health insurance, without any health benefits. There was no set work hours for the week. There was no pension plans, no retirement, nothing, no worker safety plans. That was not in place. And because the American workforce says enough is enough, we demand to have a voice about our conditions of employment and our conditions of work. And they rallied, and they supported, they lobbied, they done everything possible to include having a work stoppage. The Congress finally said, yes, there should be a voice in the workplace, and here's what we're going to do. That's where we are again today. We find ourselves right back in the same boat we were 100 years ago, or nearly 100 years ago, in fighting for the American worker. Now, what does it mean to not have a union? What does it mean to not have a voice in the workplace? That means your employer can walk up to you and say, we're going to cut your salary, and we're going to cut your salary by 25%, and you don't have a voice. Your employer can walk up to you and say, we're going to terminate your employment, and you not have a voice or representation to stop it. In other words, a right to work sake. That's what the administration is trying to do with getting rid of the contracts. But I'm here to tell you that we are fighting against that tooth and nail. And not only have we filed against that, there's also been additional lawsuits filed against the agency claiming that they're going to terminate the employment of furloughed employees and they're going to not give them their back pay. We want you to know that the union has already filed in district court against that threat from the agency that they're going to terminate and fire furloughed employees during the shutdown. That is illegal. Period. It is illegal. Okay. So additional lawsuits have already been filed. And this is one way of them trying to say, hey, let's do a RIF, and we're going to do it through the government shutdown. We have already, the union has already filed against that. We just want you to be aware of that the union is not sitting back on their hands and not doing anything. Them process and the court filings have already taken place. Okay. Now, we also want you to know that what's filed in the circuit court is not on the merits. It's only on the injunction. Okay. So keep that in mind. Keep that in mind. The Ninth Circuit Court is on the injunctions, not on the merits of the case. The merits are still moving forward. Now, we've had, in the past week, we've had about 3 to 4 grievance meetings with the agency and helping employees in their conditions of employment. And we believe that's important to continue to fight for every employee because we know that the union has a role. The union has a role in how we defend and help employees. And the 3 grievance meetings, 2 of them were with national union representatives who met with the agency. So the union is still meeting with the Department of Veteran Affairs about conditions of employment involving bargaining unit employees. When I said to you before, the union is not dead. We are not dead, okay? So don't let that voice that keeps echoing, there is no union, there is no union. The union is still here and we're still fighting on behalf of employees, all right? Now, some of you should have received by now your COVID leave. We signed that agreement, God, I want to say back in April, May timeframe. We got our part to the agency. I believe within the 60-day, the 30-day window, we needed to get that to them. So by now, employees should be receiving their COVID leave. That reimbursement should be given back to them by now. We're in the month of October, so everybody should be getting their leave back. You should look on your leave and earnings statement, okay? So when the COVID leave is reimbursed to you, it should be restored leave on your leave and earnings statement is where it should show up at, okay? So it'd be at the leave portion of your leave and earnings statement where it says annual leave, sick leave, whatever down there. There should be a line that says restored leave. Your leave should be restored on your leave and earning statement, okay? They're not just given to you in the VATOS, but it should show up as restored on your leave and earning statement. Those of you who had AWOLs, the AWOLs should be taken away. You should have not only should you get the pay from being marked AWOL restored, but you also earned leave. You earned sick leave. You earned annual leave. You earned investment to your TSP. There's a lot to be restored with the removing of the AWOLs, okay? So that should also be occurring, and we will continue to keep you abreast of the issue as we move forward, okay? Now, currently, we have several employees that we're still fighting for, and this is how you know whether or not an agency cares about its employees. We have about 8 to 10 employees who are disabled employees. They have reasonable accommodations, and the agency is not honoring their own handbook and the Rehabilitation Act of 1973. We have brought this to Mr. Graspy's attention on multiple occasions. And as a medical center director, he has a responsibility to the employees that work at his hospital. And you, as a medical center director, cannot keep passing the buck saying, that's what HR, we have nothing to do with that. Anyone that makes a decision impacting employees at your facility, you have a decision in. And Mr. Graspy right now has the ability to fix the issues of the disabled employees at our hospital. Disabled employees are employees that can work, they're able to work, but because of their disabilities, they need a reasonable accommodation. The Reasonable Accommodations Act and law was put into place so that employees who can gainfully work but are disabled are not discriminated against. If an agency is willing to discriminate against employees with disabilities, you can only imagine what they would do to employees who don't have disabilities. You heard me correctly. If you are not willing to take care of and support your disabled employees, and on top of that, you call yourself a medical center, a place to get treatment and help, then what are you actually doing? If you're not willing to take care of your own, support them, your own, we know damn well you're not going to support an employee who does not have a disability. So we are calling on Fabian Grasping to get off the couch and help these disabled employees, and stop burying your head in the sand and say, I don't know anything about it. I don't know. No, you know about it because we shared it with him repeatedly over and over and over. The agency, meaning Mr. Graspy, should not be allowing HR to impact his workforce adversely. And here's part of what's happening. LaWanda Newton is in charge of reasonable accommodation, her and Abner Martinez. LaWanda Newton and Abner Martinez have both been found liable. They have both been found liable for sex and or race discrimination and anti-union animus and employment discrimination as it relates to reasonable accommodations, disabled employees. LaWanda Newton has been telling people for over 2 years that employees have exhausted. You've exhausted your reasonable accommodations. You can't ask for any more. Oh, I'm sorry. And Carlos is in that boat with them as well. There is no such law, rule, or regulation that makes a statement you have exhausted your reasonable accommodations for a certain time period. It simply does not exist. And for the agency, the local agency and or division, to allow those lies to continue to be spilled and told to bargaining employees shows a discredit upon them as the director of division and the director of local agencies. Employees who are needing help through reasonable accommodation should not be denied reasonable accommodations for capricious and arbitrary reasons. Because when you have the medical documentation and the medical doctor's recommendations for the reasonable accommodations, that's it. Full stop. Grant the reasonable accommodation. There is no such thing as, well, I don't believe the doctor. It's not their point to believe the doctor or not. Once they receive the information, reasonable accommodation should be granted, period, full stop. And we need the director to get off the couch and start helping these employees who come to work for you, to help you get your paycheck, you should be supporting them just like they are supporting you, period. All right. Additionally, we're still fighting. We have 11 employees who are owed back pay for merit promotion violations. We have 11 employees that are owed that money right now. Some of them have not been paid the appropriate back pay. Some of them have not been promoted properly. They have not been paid the proper interest. They have not been paid the locality pay, the agency, and they keep trying to blame somebody else. It is a sorry individual that keeps trying to blame someone else for not taking for your failure. Could you imagine your mom or your dad supposed to be providing support for you and food and funding and finances? What if your mom or dad came to you and said, well, I know you're my son and I know you my daughter, but I'm waiting on this person over here to do their part before I can pay you your benefits or put food on your table. That is ludicrous, absolutely ludicrous. And that's one of the things that we liked about Mr. James Warren so much. Mr. Warren cared about the employee. Mr. Warren had a principle that if you take care of your employee, which is one of your most important commodities and stakeholders, Mr. Warren said, if you take care of your employee will take care of your customers. That was a great model to have. And while Mr. Warren was in the interim director's seat, that is what we live by. And that's the reason why we have the COVID agreement. That's the reason why there are about 12 or 13 settlement agreements signed and employees were made whole while Mr. Warren was interim medical center director. Okay. And because he put the employee first and because he put the relationship of the agency and the union as a priority, we were able to resolve them issues informally. We were able to pull issues back from arbitration. We were able to pull issues back from the Federal Service Impasse Panel, sit down like adults, grown men and grown women, and resolve them sitting at the table. That's what you're supposed to do. And because Mr. Warren was so successful at that, people at the Visit 15 office and some at the local agency did not like Mr. Warren, to include one of our union representatives. Now, I'm not going to mention his name because he's not worthy to even be mentioned. But because Mr. Warren worked so good with the union and the employees, trying to make sure the employee was taken care of, for that reason, he was targeted by visiting human resources people and by one of our union reps in our facility. Like I said, I'm not going to mention his name because his name is not worthy to be mentioned. But because of that, they targeted Mr. Warren. One of the complaints filed against Mr. Warren was because he worked with the union. They actually filed a complaint to try to get Mr. Warren disciplined and terminated because he worked with the union on behalf of the employees. Imagine that. Imagine a medical center director being targeted for working with the union on the employee's behalf. Imagine that. Imagine it. And ask yourself, what world are we living in when a medical center director who stands up for his employees are targeted by other managers in the agency and human resources in the agency and Vision 15? The medical center directors swore an oath that they would take care of the employees, period. And imagine being targeted because you took care of employees, meaning you made sure their paychecks were correct. You made sure that they got the proper pay. They got the proper benefits. This is what makes government work as it should. When your leaders take up a position that I'm going to support my employees and defend them and make sure they have the proper pay, the proper benefits, they have safe working conditions. When that happens by a medical center director, you have a good medical center director. You have a good one. You do. Because they put people, the employees, above all the other noise that happens around them. And for that reason, Mr. Warren was targeted. We also believe Mr. Warren was targeted because of his race. Mr. Warren had a gentle approach. He was opening. He was inclusive. That's the motto he had when he was at the previous hospitals he worked at. That was the same motto. And that motto worked everywhere else he had ever been. And it also worked in Poplar Bluff until they started to target his employment. Imagine that. Just imagine your director of your hospital being targeted by Business 15 human resources people simply for taking care of you and I, the employee. Okay? Now, there are additional issues that are being fought for right now in the workplace. So we want you to keep your head up. Keep your head up. Keep your head up. We're going to win this battle. We're going to win it, and we're going to be successful. But it's going to take people like me and you sticking together, talking with our neighbors in our neighborhood, talking with our friends and family members about the importance of unions in the workplace and the importance of what we do and how it impacts them as well. All right, so God bless you. Have a good day, and we will continue to be in contact with you as we continue to move forward. Have a good day.